Regulations 2021. We may begin with a word of prayer. Any volunteer to pray for the forum? It's always good to start the meeting with a word of prayer to seek God's guidance.
Just pick somebody from the list, Kapeko.
From
you
the
have
panel.
everybody. Just do a random checking of the list and pick somebody.
Okay. Let me see who can pray for us here. Grace Kimani. Or Agayo Gambi. Agayo Gambi, can you pray for us? Oh, Grace Kimani. Agayo Gambi or Grace Kimani, can you pray for us? Kindly. Yes, Agayo.
Let's pray. Heavenly Father, we thank you for the gift of a new day. We want to thank you for this forum that is going to discuss issues affecting our livelihood. We beseech your guidance. We beseech your mercy. We thank you, God, because you have been merciful to us and you have been kind to us. Even for the work that we do, Lord, may it be blessed. For your word says you bless the works of our hands. Bless the panelists, bless the moderator, and also bless the participants. For this we pray, trusting and believing in God. Amen.
Now let's begin our program. This is the third public participation on KMA laws, the amended laws. And the first session or the first public participation was held in Mombasa Beach on 23rd. And it was primarily focusing on the maritime transport operators. The second public participation was held on the 1st December at the Nyali Sun Africa Beach Hotel. And this again was the target audience was the partner government agencies. We received several comments towards improvement of the bill, and this was really appreciated. And we encourage all the participants again to continue making comments through the provided link, and the deadline is on 8th of December for the comments. For today's meeting, this is a virtual meeting. The two were physical meetings. This is the third public participation meeting, which is a virtual meeting. And we have a program with us here. I think, can the program be screened, please, for all to see? So today's program will begin with preliminaries. Welcome remarks by Mr. John Omingo, the Director of Maritime Trade and Development. Then thereafter, there will be an overview of the Maritime Laws Amendment Bill 2021, a presentation by Madam Catherine Kiviki. Then it will be followed by a health break of 15 minutes. Then thereafter, there will be an overview of the Merchant Shipping Maritime Transport Operators Regulations 2021 presentation, again by Madam Catherine Kiviki. And thereafter, there will be a plenary session. The moderators of the session will be John Omingo, or the panelists will be John Omingo, Mr. John Omingo, Mr. Kalfan Baya, Mr. Kapeko, Mr. Ella Kiangu, and Mrs. Catherine Kiviki. After the plenary, we'll have a way forward and a closing remarks by Mrs. Jen Flores Otieno, who is the Head of Legal Services and Corporate Secretary at the Kenya Maritime Authority. And thereafter, it will be the end of the session. Thank you so much. So we may begin the program with the remarks by Mr. John Omingo. Thank you.
Thank you. Thank you, Kapeko, for opening up the session. and telling us what to expect, and also narrating the engagement that we have had before since we started this process. And so then I must commend the participation that we have received from the very first session that we held. We had close to 60 participants came in, and we had very interactive and engaging process to get to understand what we mean by the various clauses that we have in the amendment bill and also in the proposed regulations. We also had an engagement with the government agencies so that they could also bring out some of the issues. And we had over 15 various agencies attended the session we had last week. And again, we also generated a lot of engagements in terms of seeking clarification on some of the issues and also giving comments. But most importantly is the provision for a standard form that we gave in both occasions, and we'll also be alerting you of its existence in the downloads that we have provided, so that you'd be able to pick on the specific issues and formalize your comments or additions that you may wish to share with us. And for the purposes of making sure that your views are recognized in this process, the legal team, together with us, we have undertaken to respond to each and every input that you have made in regard to its our understanding of what you are suggesting and how it has been incorporated in the drafts. And if you give a particular point that perhaps we may not put in, then we'll also be able to explain why that one is so that your presence in this forum and the other forums, you will get to know that we will not take it for granted. We thank you once more for taking your time, very busy schedule, to be able to give us your ears in this kind of a platform. And so to participants that have recognized from the list of names, thank you, Mr. Agayo, for your very blessed prayer. Such prayer comes from experience. You are a praying man, and we thank you for blessing this occasion so that we can have a successful session. And so then on behalf of the Director General, Robert Njue, who is held up out of the country in another very important national engagement to do with our election into the membership of the IMO Council and the engagement that they are having. It is because of coinciding engagements that they have scheduled with in the process that they are taking right away, that he sent his apologies and was not able to be with us today. But in the participations that we have had, he would normally come in and give us some remarks and encourage members to feel free to participate. And I assure you as well that whatever you say will be taken very, very seriously as we work out on how we can be able to fulfill the true spirit of public participation as required in our constitution. And so on his behalf and behalf of the entire legal team, headed by Catherine Kitiki, who have put these documents together with the Office of the Attorney General and other friends and technical experts who have assisted us, I just want to welcome you to look at the works of what they have done, which has come from a series of consultations and also from the experience that we have had in the past. As many of you are aware, we had our first Merchant Shipping Act was set up in 2009. The regulations came out in 2011. And these regulations, because of certain clauses, they were contested in court, and it took quite a long time, about more than 5 years, for the courts to make a decision on the way forward. And that put us in a state where we could not implement those regulations. Now, we looked into the court matters, as Catherine will be able to narrate to you the summary of what informed the papers that you had received and which will be presented to you here. We had to take into consideration all those issues and come up with the things that would also get us to move. We as KMA, we are conscious of the need to ensure that the safety of shipping operations is assured, that the pollution issues are properly addressed, and that the developments within the sector are properly captured and addressed, and that the efficiency of the maritime transport logistics is assured by providing an overall governance framework that will be able to address some of the issues that we have been facing. Now, so many years without this very specific regulation that would have sorted a number of problems is not a good thing. And so then we hope and trust that your conscious effort to look into the documents very, very objectively and clearly, and take your time to read and write to us what you think, it will not go in vain. It will help us to streamline and begin now to effectively provide the necessary governance frameworks that is required for this sector. Again, I wish to point out that from the last time that we engaged, we thank the Shippers Council. Actually, the initial engagement, they really actively participated, and other participants. So many things have taken place in the industry. The perception of the sector has changed. The challenges have also changed. The infrastructure has moved. By then, we did not have the port community charter. Now we do. That gives a framework for each and every participant in the logistics chain on how the indicators of performance could be measured, could be assessed, just to see how good or bad we are performing as providers of maritime transport services. And so these changes have been incorporated with the overall goal of how do we address the issues of accountability in terms of performance of the government agencies as well as the private sector in areas where competition is hardly defining the parameters of efficiency. Where competition is existing, you don't have to work very hard. But where there is no competition and the services are sometimes on a take it or leave it basis, then it becomes a challenge. And so then there is need to set out where the services is on a take it or leave it basis, then what are the minimum standards that we have to meet? Because if we don't, then it becomes a very costly exercise for the receivers of these services. And so then in addressing the accountability framework, we have tried as much as possible to bring how do we deal with the government agencies, how do we deal with the private sectors, and Catherine will be able to explain all these ones to you in details. So in a nutshell, I just want to take this moment to welcome you, to encourage you to actively read the documents and follow the presentations. And thereafter, we'll be very happy to receive what comments you have to say and how best we'll be able to move forward. So I just want to stop at that point and wish you a very good listening and a very good active participation as we look forward to hearing from Catherine in her very clear voices and loud and sharp. You'll be able to get to know what are the details that we have for you this morning. So I encourage you not to leave the room. There's no exit. There is only entry. So we'll be exiting all together. We'll be seated here together. Please don't get diverted by other activities. Just keep your attention focused because it's a very important exercise that we are doing so that at the end of it, we can be able to benefit from your very serious attention that you have given to the process. Otherwise, I just want to thank you and welcome you and possibly declare this forum formally open. And karibuni sana, asante sana. Thank you.
Thank you, Mr. Omingo, and thank you, Mr. Kapeku, and welcome our esteemed participants. I'm going to try and see if I can project my presentation so that we can progress the session. share. I trust you can see the presentation. Okay.
Yes, I see it, Catherine.
Excellent, thank you. So we will first begin with the presentation on the Maritime Laws Amendment Bill 2021. And basically the process of the review we have proceeded to review both the Kenya Maritime Authority Act 2006 and the Merchant Shipping 2009 Act. Now, the basis of the review entailed a number of documents and this recommendations from various documents. And this included the consultancy report on alignment of the laws in the maritime sector to comply with the provisions of the Constitution of Kenya 2010. This includes provisions in terms of consultations at various stages of provision of services. It also touches on aspects of administrative or fair justice, and also further provides on generally definitions such as the cabinet secretary as opposed to what it was known before the minister. In addition, the review incorporated recommendations in respect of the Integrated National Transport Policy 2001. Specifically for the maritime sector, it provided that there shall be a system of regulation of commercial maritime services. Now, as we understand, the Integrated National Transport Policy 2009 is currently under review. We have a 2020 and I believe 2021 version. And so some of these provisions have actually been incorporated in the reviewed version. And as such, we are seeking our amendment seeks to now implement this recommendation. There were several recommendations also made under the World Bank project on strengthening the authority's oversight capacity in terms of maritime services, maritime transport services within Kenya. And this took into account practices experienced in South Africa as well as in Germany. And it made several recommendations on how we can improve our oversight functions as well as improve efficiency in provision of services. We also have the report on the IMO mandatory audit, and this was in 2018, which made several recommendations of various international instruments that we have ratified under the IMO mandatory instruments, some of which include ensuring safety navigation, among other aspects. So the review process has incorporated this aspect. As was previously mentioned by by Mr. Omingo during his opening remarks, we have the Mombasa Port and Northern Corridor Community Charter. As most of you are aware, this tool was developed and was endorsed by our president, and it requires us to provide an oversight and efficiency in quality and cost of cargo clearance processes. So the Mombasa Port Community Charter and Northern Corridor provides for recommendations and tasks and duties in respect of every operator within the sector in terms of clearance purposes. And as such, as also the regulator, this being the Maritime Authority, has also been provided for a function in terms of monitoring and coordination, as well as oversight. So these provisions have also been provided within the functionality of the authority under the specific provisions under the functions of the authority. Now, we also have the third medium-term plan, 2018-2022. As most of you are aware, it provides for the need for the country to establish a framework to support local investment in the maritime sector and to facilitate the growth of entrepreneurs in the emerging blue economy with opportunities. Now, again, the review of the Act, both the Kenya Maritime Authority Act and the Merchant Shipping Act, as well as certain provisions within the maritime transport, the Merchant Shipping Transport Operators Regulations, also incorporates these aspects. We have the Ministry and the Authority Strategic Plan, which takes into account both regional and international initiatives on how we can grow the sector. These aspects have also been incorporated. We have other international instruments to which Kenya has ratified, and more so in terms of the IMO, which are not part of the mandatory instruments, but include the FAL Convention in terms of ensuring or provision of efficiency in provision of services for purposes of an expedited or expeditious clearance of cargo or passengers or crew members from one port to the other. We also have the obligations that under the General Agreement on Trade Services. Certain aspects of this, more so in terms of tariffs, have been incorporated in our laws. We have also government directives that have been issued in respect of commercial maritime services, to which most of us are familiar with. This has also been incorporated. We've also included the Blue Economy recommendations following the conferences in Bomet and in Nairobi. And also, as you will recall, as intimated by Mr. Omingo during his opening remarks, we have the Constitutional Petition 76 of 2012. You will recall that at that particular time, we had the Maritime Service Providers Regulations, which sought to regulate and provide oversight over maritime service providers within Kenya. It provided for the respective maritime service providers. It provided for their functions, as well as the services that are going to be delivered and what aspects would entail regulation and oversight. Now, certain aspects of this constitutional petition led to the Maritime Service Providers Regulations being declared void in its entirety. And unfortunately, one of these aspects was in terms of the process in which the law was made. So this is an area which was challenged. In addition, there was the aspect of introduction of penalties within those regulations, which were not supported under the main act, that is the Merchant Shipping Act. And as a result, these regulations were declared null and void. However, during the court's decision in its judgment, the court noted that several provisions provided within the Maritime Service Providers Regulations were actually constitutionally valid. And as such, you will find that in our regulations, we have incorporated most of these provisions. However, we have rewarded them or recasted them. Now, in the development of the review of the Kenya Maritime Authority Act, as well as the Merchant Shipping Act and the subsidiary regulations, we were able to engage officers from various institutions, and this entails Kenya Ports Authority, Kenya Law Reform Commission, who are our main drafters. Then we have the judiciary, we have the competition authority in matters of fair competition and limitation of restrictive practices. In terms of the judiciary, we have the provisions on appeal process within an internal mechanism which has been established. And then also, in addition, we have the provisions for establishment of a tribunal, which will be entailing officers some from the judiciary, some from the sector, on determining on pertinent issues that affect the industry. We also had participation from Kenya Revenue Authority, KEBS, and the ministry. Now, the proposed bill, as I indicated earlier on, it's under an omnibus law, which is known as the Maritime Laws Amendment Bill, and it reviews the Kenya Maritime Authority Act as well as the Merchant Shipping Act. Now, under the Maritime Laws Amendment Act, we have reviewed various provisions under different parts of both acts. Under the Kenya Maritime Authority Act, we have reviewed Part 1. Part 1 provides for preliminaries in terms of the definitions and the long title of the act, which now includes oversight, as well as it also extends to defining now who a cabinet secretary is, among other definitions that you will find within the draft law. Under Part 2, we've also reviewed Part 2 of the Kenya Maritime Authority Act, which provides for the establishment and functions of the authority. Some of these include the basically where the offices of the authority shall be based, which shall be based at strategic locations. And then we have the expansion of the functions of the authority, which includes now aspects that were left out following the IMSAS audit under the IMO mandatory instruments. We also have the aspects provided under the Mombasa Port Community Charter, which have also been incorporated under the functions. We have aspects of GATS, which have also been incorporated under the functions, among other provisions. In respect of Part 3, these are generally the administrative provisions provided under the Kenya Maritime Authority Act. We have amended provisions such as the period of the term of the Director General, And this is to comply with generally the current practice within the public sector of ensuring that and the officer is able to deliver the strategic objectives within a given period of time. We've also sought to amend provisions in respect of who the corporation secretary shall be answerable to or shall be executing functions for. In respect of the provisions under the Miscellaneous Provisions Act, miscellaneous provisions, we have incorporated the requirement for the authority to be making publication on publication reports on general reporting on matters pertaining efficiency in terms of provision of commercial maritime services. Now, this will go hand in hand more so in terms of now the functions of the authority in terms of realization of the objectives under the Maritime Port, the Port Community Charter. We also have the second schedule of the authority. This generally seeks to make amendments to the provisions, the procedures of the board during the deliberations. And these are minor amendments. Now, in respect to the Merchant Shipping Act, as most of you are aware, the Merchant Shipping Act is it's quite a huge act. It generally provides for most aspects of what entails the regulation and the provision of safety provisions in terms and security provisions in terms of the maritime sector and obligations of not only the authority but also obligations which are in respect of the entire safety, security, and provision of maritime transport services. So under Part 1, we have introduced the definition of a maritime transport operator, who it entails. We've also provided for other definitions, including a cabinet secretary and what the act is, which in this instance shall be the Merchant Shipping Act. In terms of administrative provisions under Part 2, we've provided for a provision in terms of consultation between the public sector and the private sector. As most of you are aware, the FAL Convention, to which Kenya is a party to, requires both the government and the private sector to be able to collaborate and to consult to ensure efficiency in terms of provision of services. And it is in this respect that a provision in that aspect has been provided for consultations. We also have, we also have reviewed Part 3, which deals with restriction on trading of the Merchant Shipping Act. Now, as most of you will recall, the restriction on trading mostly provided on the Section 16. And you will recall that Section 16 was recently declared unconstitutional following a recent court proceedings. And as such, during our review process, we deleted the provision that was there and incorporated a new provision, which is in compliance with the Local Content Bill, as such seeking for the promotion of local content. Under Part 3A, this is a new part that we've introduced, which was not there before. Now, Part 3A specifically gives life to Section 8H in terms of regulation and oversight of maritime transport operators or maritime service providers. And in this respect, we've provided a new part which provides for aspects of registration, cancellation, revocation of licenses to maritime transport operators. We've also provided provisions on fair competition and to address issues of also restricted competitive practices. We've also provided for provisions that relate to tariff introduction and tariff review, which is also in compliance with not only the WTO agreement, but also among other regional and international practices on what a regulator should actually be undertaking. In addition, we've provided for provisions on submission of reports in this part, provisions on regulation of the maritime transport operators sector and who they entail. Now, under Part 4, we've reviewed a section on it just to ensure that we comply with the SOLAS Convention. Part 6, we have provided we have also reviewed a section more so in terms of re-reference of a terminology to comply with the international convention in respect of how we go about registration of ships. Under Part 7, we've provided for the engagement and welfare of seafarers. And in this aspect, we have reviewed the definition of a seafarer to comply with the Maritime Labor Convention 2006. We have also reviewed the terminology of crew agreement. You will recall that there was reference to crew agreements and within that part, and the provisions that were provided therein in respect to the old version of the crew agreements. So what the committee has done is with the consultation and consultation and supervision of our Kenya law reform expert is to review the provisions so as to ensure that we comply with the Maritime Labor Convention. And this is in aspects of who a seafarer is, the seafarer's employment agreement. We have also expanded the scope for the part to include to seafarers or Kenyan seafarers who are also on board ships on international voyage. We have also provided for certain provisions in terms of the establishment of a monitoring system for recruitment and placement agencies in terms of seafarers. Under Part 20, this is a part known currently as the legal proceedings. In this part, our esteemed participants and the panelists, we have sought to introduce provisions in terms of an appeal system, and where an applicant or where an operator is aggrieved by a decision made by the DG or by the authority, they have a right to appeal internally. And then if they're still dissatisfied with that response, they also have a further right to appeal to the tribunal, and to which a tribunal will be established and the matter will be determined. And again, where they're still aggrieved and they're not satisfied with the decision of their tribunal, they still can elect to pursue the High Court provision. Now, the introduction of this appeal system was with the support of the judiciary, in that government institutions or regulators should see how they are able to provide an appeals mechanism or an appeals procedure, including the establishment of a tribunal within their institutions. We also have made amendments in respect of where a client is dissatisfied with an action of a surveyor who's been appointed to undertake a survey on board a ship. And based on international practice, we noted that there was a requirement to proceed to alternate dispute resolution as opposed to filing a matter straight into court. So these are also aspects that we've incorporated. Now, under Part 21, here we've introduced other miscellaneous provisions in terms of just in terms of the workings of the authority and the provisions to proceed with other dispute resolution mechanisms. So just take it back a little bit. Maybe for Part 7, Part 5, 6, 7, 8, on safety of navigation and prevention of collusion. Again, this was to ensure that we comply with the provisions based on international instruments. The same goes for Part 9. And in part also 17, on limitation and division of liability of maritime claims, we've also ensured that we comply with the existing international instrument, to which an amendment was made in 2015. So we've just generally reviewed the rates to comply with that amendment as being a member state. So in summary, the amendments of the Kenya Maritime Authority Act and the Merchant Shipping Act seek to enhance the regulatory function of the authority. It amends the interpretation clauses both under the Kenya Maritime Authority Act and the Merchant Shipping Act. It also reviews the functions of the authority to ensure that it recognizes and incorporates related government agencies involved in maritime transport and logistics chain. And the amendment is to seek for an efficient and effective and reliable, an effective, reliable, and globally competitive Kenyan ports and transport corridor. It also seeks to ensure that we're able to achieve synergy within the transport and supply chain, to provide for stability and to provide also for predictability in terms of provision of maritime commercial services. It also seeks to rectify errors that were there before. It introduces and establishes a reporting mechanism for purposes of performance performance standards and reporting on matters of attaining port efficiency. As I indicated earlier on, it talks about the establishment of a National Maritime Review Tribunal. It addresses aspects retaining to or relating to the Maritime Labour Convention. It introduces provisions on promotion of stakeholders' engagement between the public sector and the private sector. I believe the rest I've also mentioned, so we can, I believe this is the end of the presentation. Yes, sorry, I'm in section 2 to 7 of the Merchant Shipping Act. There was the provision on, again, this goes back to the era, whereby the system of categorization of Kenya, which is in Africa, initially was placed in letter B. So now we are rectifying it to letter A. And the rest is in compliance with the provisions of the Constitution. And yes, under miscellaneous, this is a very major introduction that we've introduced. And this is the insertion of a new section, that is section 448A. And section 448A is seeking for the establishment of a maritime cluster fund. As most of you are aware, under the third medium-term plan, there is a recommendation made that we are to try and see how we can build up the maritime sector in Kenya. And this is through establishing a fund that can cater for various aspects. And as such, we have established a maritime cluster fund under the Act, and this shall be in consultation with the provisions contained under the Public PFMA Act. And the purpose of this fund would be for purposes of seafarers training, women in the maritime sector, development fund for the sector, shipping and maritime training, and also organizing clusters in the maritime and shipping subsector. So these are a number of amendments which are made to both the Kenya Maritime Authority Act and the Merchant Shipping Act, that we hope that we are able to work together to try and see how we can push them forward so that we are able to improve our sector within the region and as well as internationally. So that is the end of the presentation for the first part of the presentation. As has been indicated earlier on by Mr. Omingo, we have published our draft laws on our website, and that is the link. And in addition to that, we have a template on comments or review of the proposed draft laws, which you can send them to us by latest 8th December 2021. Thank you. Mr. Kapeku, back to you.
Thank you, Catherine, for the elaborate presentation on the first topic, that is the merchant shipping laws. Now, I think the Acting Director General, Mr. John Omingo, gave a highlight, a brief remarks on DG's remarks, and some of the issues are regarding why are we having these amendments in terms of maritime industry itself is very dynamic. There are so many international developments which have happened, local development, regional developments which have happened, and the laws, the amended laws have incorporated those aspects. In addition, the issue of the Mombasa Port Charter to be incorporated in the laws, and it's provided explicitly in the charter also that one of the role of KMA is to come up with regulations to support the Mombasa Port and Northern Corridor Community Charter. The other aspect, Catherine gave an overview of the Maritime Laws Amendment Bill, and the key, I think, is the issue of the historical case which we had in 2011, and that necessitated or was one of the rationale why we needed to come with the amended laws. The other issue is the issue of the WTO trade facilitation agreement to be incorporated again in the draft laws. The IMO FAL convention need also to be incorporated. Aspects of our national policy objectives, such as the MTP3 medium-term plan 3 of the Vision 2030, and also the integrated national transport policy. All these are important in order to achieve what you call improved socio-economic development in our country, and also for all the stakeholders to benefit in terms of opportunities in investment, opportunities in employment. So we are having a break of 15 minutes, health break. What is the time? Or do you think we need to continue with the next presentation before we come to the plenary? Any contribution on that?
Through the DG acting or Gambi here?
Yes.
Yes, for Gambi.
My suggestion is if agreeable, we raise some questions or comments at this point so that we do not lose track of what we have in mind. We strike while it's still hot. I just want to appreciate Madam Catherine for the excellent presentation. So my take is you open it up for plenary kindly, and then we possibly take a break, then come back to the next session, take questions, and then we conclude at lunch.
Any other proposal?
Okay. I'm just wondering, for virtual sessions, do we have breaks? Because people are fresh. So we may not need the break, Kapeko, because if you go for a break, others may leave the room. Mm-hmm. So it would be okay if you go by Ogambi's suggestion that we take up issues on this presentation, and once we are done, we just breathe in, breathe out, and then comes. Yes, and we proceed on. Physical meetings, yes, you need to break and take a tea and mingle around, but for these ones, we are taking tea even as we listen and moving on. So we can as well just proceed and see how it goes. Thank you. That's what I'm proposing.
Okay, thank you, Mr. Omingo. You have heard. So let's continue the plenary session now for that is the question and answer session. I think the approach will be for the participants to raise their hands. There is an icon to raise hands there. You can use that icon. So kindly, anybody who would like to make any comments or to give input, kindly raise your hand.
My hand is up.
I'm not seeing you raise. Okay, Agayo, you can start, Mr. Agayo.
Thank you, Catherine, and thanks, Mr. Kapeku. First is to register our appreciation that at least the revision incorporates the port charter. We look into how that is being done and then how it has been strengthened. But I have an interest in the local content, given the fact that the previous provision of Section 16 was invalidated by the court. So I'm just seeking from Madam Catherine, if she can just show us a highlight of what the local content is like. One. Secondly, there's a feeling that the multinational and the bigger companies are kind of taking out the SMEs in the country. How is that also addressed in the revised act? So I have an interest in that local content aspect. Number two is the cluster funding. Who is going to fund it? What's the source of the revenue? Who is going to manage it? And the reason for this is the industry feels already overtaxed. We have RDL, we have various charges that supports KMA, for example. So is this going to be double dipping on what's the source of this fund and how is it going to be managed? What is the role of the private sector in that fund? So that is clear from the beginning. I appreciate the need to support seafarers, the trainings, but again, it's just good to appreciate what shape it's going to take. And then I'm also excited about the role of KM in ensuring standards delivery. I'm not sure if KMA will have the mandate to discipline fees and charges, which continues to remain a big challenge for the industry. So those are the issues: content development, local content, the funds, the cluster funds, discipline fees and charges are issues that we'd like to make clearer. And then finally, on behalf of Nairobi, we feel a bit disappointed that we did not have a physical meeting in Nairobi, and we had hoped to have one in Nairobi. So we just want to register our disappointment on that. But thanks for the presentation. I submit.
Thank you, Mr. Agayo Gambi from the Shippers Council of Eastern Africa. We invite other participants, kindly raise your hand or make comments on the Maritime Law Amendment Bill 2021. Kindly, participants, feel free to engage. Let's have an active interaction.
Yeah, good morning.
Morning. Kindly state your name and the institution you're from.
Yes, my name's Roy Mwanti. I am the national chairman of Kenya International Freight and Warehousing Association, KIFWA. I want to appreciate KMA for coming up with this amendment, maritime laws. They've been long overdue. However, I am particularly concerned with Section 9 of this maritime. Just a minute, want to open. Yeah, Section 9 of proposed maritime shipping transport operators regulation 2020. My concern is on item where clearing agents are required to register and to be licensed by Kenya Maritime Authority. The issue here is that clearing agents are licensed by under East Africa Management Act and by Kenya Revenue Authority. And we pay an annual license of $400. This annual license is equal for all operators in the field of custom agents and clearing and forwarding in the entire EAC region. And all of us as custom agents, because EAC has integrated, we are mandated to work cross-border because we also had the training of East Africa Freight Forwarding Practicing Certificate, where when one attains that course, is able to operate from Uganda, and Ugandan agents are able to operate in Kenya, and vice versa with Tanzania, Rwanda, and Burundi. So now, if we introduce some charges called registration of custom agent under KMA, it would amount to first duplication in terms of KRA is collecting the license fees and KMA is also collecting license fees. Number two, because I believe this law is meant for Kenyan custom agent, then there will be unfair treatment where Kenyan custom agents are required to pay even KMA, and the ones of Uganda, custom agents for Uganda who are operating from Port of Mombasa are not being charged the same. So, I mean, we will not be able to compete competitively in the region because our license fees would be double or would be more higher than other agents in Uganda. And again, this law can only be amended from EAC, the East Africa Management Act. So if KMA wants to charge custom agent, then they must go and amend the law at EAC level to make all agents in the region operate at the same level. but you cannot introduce licensing and registration fees annually for Kenyan Karelian agents, and you don't do the same for other agents in the region. So it is our submission as KIFWA, and we have already done the initial submission, that section where Karelian agents are required to register and to renew their licenses with the KMA be vacated, because it is contradictory. It is in contradiction mode to ESC Act. Chair, I want to submit, because KMA is for fairness. It's not standing in gap to increase just the license fees and, on agents who are already overburdened by COVID pandemic and by other factors of life. Already, the businesses Karelian agents used to perform, and I believe the regulations also address in another portion that we have players called the shipping lines, who are actually have in-house Karelian and the forwarding company. They operate transport company, they operate probably bonded warehouse, operate CFSs, and by and large, when they sell a through bill charge, it is cheaper than when an outsider, a Karelian agent operating from outside, the charges given to an importer when he is Karelian using a subsidiary of a shipping line, a subsidiary logistic firm of a shipping line, is cheaper than when an outside agent is offering those services from door to door, from port to the door. So, Chair, in this regard, I request on behalf of the 1,000 members of KIFWA that this section be vacated forthwith. I beg to submit, Chair. Thank you.
Thank you, Mr. Roy Mwanthi, Chairman of KIFWA. Catherine presented what you call Draft Maritime Laws Amendment Bill. Kindly make comments on the Draft Maritime Laws Amendment Bill. Mr. Roy Mwanthi, your comments are very useful. We appreciate that. But we have a session on that, on the draft, what you call Maritime Transport Operators Regulations in the next session. So kindly only make presentation or comments or input on the Draft Maritime Laws Amendment Bill, which was just presented by Madam Catherine. Thank you so much. Any other participant?
Yeah, good morning, everyone.
Just state your name and institution, kindly.
My name is Daniel Tanui. I'm the Managing Director of Mitchell Courts. Thank you, Joseph, but I was a bit taken aback by your just last comment now. I thought this was a public participation and whatever we raise here should be taken into account when minutes are being taken, other than us being asked to probably comment and write. The essence of public participation is to hear the people who participate in this and their issues taken into account. I have three very brief matters to present. One is in agreement with what my chairman in clearing and forwarding has said on issues of licensing. We really need to understand this country has moved to make doing business easy. Why are we again being subjected to multi-licensing, multi-payment of services which are related? We really need to understand who is in charge of, which government agency is in charge of, what sort of institutions fall under it. As CFSs, for example, we are licensed under ECMA, just like clearing and forwarding agents. And we go through a due process. We get our license, we pay fees there. We are surprised to see that, again, another government agency wants to, again, take us through a licensing process and make us pay another fee. Is it that the government is working with multi-agencies to regulate a single entity. The second thing is on even these fees, how are these fees determined? What criteria was used to determine that a clearing and forwarding pays this much, a CFS pays this much, and any other institution which is to be surcharged? We also haven't seen the services which is going to be offered to, especially the CFSs, for justification of the fees to be paid. My final comment is on the issue of, I don't know whether this new act will address this. There is definitely a bias against local entities by the previous KMA regulation, in that when it comes to licensing, especially of the local shipping agents, the requirement, the due diligence requirement for local companies are far, far higher than those of multinationals. For example, local registered companies, which are Kenyan, are required to present certificate of good conduct, which is not a requirement for a multinational. So one wonders, is it that Kenyans, we are actually agreeing that Kenyan companies are more corrupt than multinationals, to the extent that we subject them to a very tedious exercise, whereas the multinationals are not subjected to this. So we would want to know whether this would be addressed in this new KMA Act. Thank you, Chairman, and I beg to make my presentation.
Thank you, Mr. Daniel Tanyu, the MD for Mitchell Courts. What I alluded earlier on is that we have two sessions. This first session is about the Draft Maritime Laws Amendment Bill. Thereafter, then we'll have another session, the second session, still covered under this program, today's program, where we'll be now discussing and making comments on the merchant shipping maritime transport operators regulations, which are the subject of what you're talking now. So I'll just appeal to you for now, kindly, let's discuss the maritime amendment, the Maritime Laws Amendment Bill 2021. We make all the comments, we finish. Then thereafter, there'll be another presentation on maritime transport operators, after which you will make your comments on the same. So all the comments will be made today, but kindly let us follow the program. Thank you so much. Any other participant? Any comments, so that we finish discussing the Draft Maritime Laws Amendment Bill 2021 before we go to another session now on presentation of the Maritime Transport Operators Regulations 2021, where we'll seek also further comments from you. Any other participant? On the Draft Maritime Laws Amendment Bill 2021? That is yes?
Yes. Buona Kapeku.
Yes, sir.
Good morning, Mr. Longin from CMA CGM. Just would like to know when is the best time to review the tariff regulation proposal. Is it this session or the session after?
The session after. The maritime transport operators.
Okay.
I hope that's why we are saying kindly read through both the documents. These documents were shared through the website. They are there. Kindly
I went through it.
Yes, so that you can make.
I went through it. I was not clear which session it was, so it's clear.
Okay.
So we'll review the session.
Yes. This is a comments on Maritime Laws Amendment Bill. That is the KMA Act, amendment to the KMA Act, and amendment to the Merchant Shipping Act 2009.
Okay, clear.
Any other comment or on input?
Apologies, Kapeku.
Yes, yes.
Maybe we can allow the question on tariffs because
Okay.
there's a part we've introduced under the act itself.
Okay.
Yes, and then it's expounded further on the regulations. So we can hear the question, and then it's something that is addressed under the act, we'll address it. If it's something that has been addressed under the regulations, we can address it there.
Okay, Eugene Baptiste, you can continue on your comment from CMSCGM. Kindly make your comment on the tariff.
Okay, can you hear me? It's okay?
Yes, yes, we can hear you.
Okay, and I might have some of my colleagues from Kenya Shipping Association as well in the room. So if they want to comment as well, they are welcome. It's just that seems that there is a new proposal for regulating stronger the tariffs in the country. I just would like to hear from KMA what is exactly behind this proposal and what we are talking about. You know, what is the main objective for this tariff regulation? Is it possible to develop on this? Can we have more details?
Thank you, Eugene. Your questions will be responded to shortly. Any other comment from the stakeholders before the panelists, Catherine and others respond to those questions? Any other? The last question.
Yes, Kapeku.
The first round questions.
Yes, Kapeku.
Yes, sir.
Chair, okay. Roy, once again, I would like to know from you whether the draft laws and the regulation that we are discussing today will put in measures to prevent any player in the maritime industry. Now, when I talk of any player, I talk about the Ports Authority, the CFS, the shipping line, the clearing agents, whether we have put in place mechanism to prevent anybody from waking up in the morning and introducing a charge without seeking permission from the maritime regulator. Because over the past 1 year or 2 years or so, we have seen somebody coming out and saying, putting a notice on their doors that effectively this date, a new charge of $100 will be applicable. You take it or leave it. The laws must address such kind of scenarios so that we can have a predictive maritime cost on goods passing through Port of Mombasa. Thank you. I submit.
Thank you, Roy, for those comments, and they will be responded to appropriately. Kindly, the panelists, Catherine and the others, kindly respond to the first round of questions before we go to the second round of questions. Thank you.
Okay, thank you, our esteemed participants, and thank you, Mr. Kapeku. I will respond to the question on the local content, and I will also respond to the question on the Maritime Cluster Fund. And on the question on tariff review, I will say something shortly, and then I trust Mr. Omingo, Kapeku, and Ella can come into this. Okay, so in respect, also in the questions for local content, Mr. Omingo can also have a say in it, as well as you and the other panelists. So now, if you look at section 16 of our Maritime Laws Amendment Act, following the repeal of the other section 16, the one that you know of, no ship owner shall be trading in other related operations. So our section 16 is an emulation of what is provided under the local content bill, a proposal by our government. So it talks about promotion of participation of Kenyan citizens in the maritime sector. It provides for consideration to the employment of local persons who have the requisite expertise or qualification in various levels of operations, and to the training in accordance with the Act. It also provides for the minimization of employment of foreign personnel, and further provides for the engagement of foreign personnel where there are no available, following a system of reasonable advertisement, as in the 2 newspapers in wide circulation in Kenya and in other such medias, to determine whether there are no nationals who are able to take up those positions. Now, this provision, as has been captured, it takes into account the government directive on local content. It also takes into account the provisions contained in the immigration in terms of promotion of local employment as well as in labor, and in international practice in how a country or a nation is able to grow its local sector or local entrepreneurship. So that is how it has been introduced, and I encourage you to read it further just to apprise yourself on the content. Now, in respect of the question on the cluster fund, the question on the cluster fund has been provided under Section 448A of the Merchant Shipping Act, which is Section 29 of the Maritime Laws Amendment Act. This is on page 26. And I encourage you to look at page 27. It provides for the sources of the funds, which includes appropriation from Parliament. It includes a surcharge of 2% from the merchant shipping levy. It includes income from investments, monies generated from under the Act, penalties, and such other accruable funds. So it lists including grants, donations, and monies that may be approved or sourced by the Cabinet Secretary. So it includes an array of sources of funding. I think I will leave it to that. And should you have any further clarification on these 2 areas, we encourage you to submit your request on the comment template so that we're able to address on it sufficiently, noting our time limitations. Now, Mr. Omingo, maybe you might wish to also add something on the local content and the cluster fund before you address the question on tariff, as well as the other speakers in the panelists. Thank you. Sorry, Mr. Omingo.
Yes, Catherine.
Yes, would you like to address the question on tariff?
Yes, thank you very much. And I appreciate those ones who have listened to the presentation of the amendments and they have raised.
Si ya maziwa. Nieke kahawa mbili na sukari kijiko moja.
Wow. Ella, could you mute? We are getting your orders. Thank you. So then now we appreciate your listening, and I just want to respond to the issue of the tariffs in terms of lodging of the tariffs with us. It's not a new practice, because even in the current arrangement that we have, you have to specify the items that you are going to charge when you are applying for your licenses as a ship's agent. So that is not something very new, and it's also something not necessarily unique in Kenya. Many jurisdictions, particularly on the kind of services that are provided by the ship's agents, they would like to ask for filing of the tariffs. Even FMC in US does that, plus many other agencies. And again, the issue of tariff, particularly the ones coming from the provision of the freight logistics, it's a gray area that has given a lot of dynamics that impact on the cost of doing business. Like many of you are aware, particularly the ones who are practicing in the shipping world, when it comes to agency, they used to be funded by their principals. You sit down with your principal, which is a shipping line, you negotiate a rate, and then they pay you. And from that rate that they pay you, that commission, that's what you use to run your businesses. And then until at one point, the issues of destination charges came into the picture, And this has really distorted the cost, because in some cases you could find that the freight is even less than the destination cost. And that is an area that needs to be looked into very seriously. And that's how we came in, to make sure that we know what is it that you plan to charge. That is, I'm talking about the tariff coming from operators like the ships agents. But as to the government agencies like KPA and many others, there is also, we provided for being informed of the KPA when they are changing their tariffs. And this is something that has even been written directly from the Treasury to KPA, that whenever you change your tariffs, then you must involve the industry regulator. Because in a service where there are very little competing suppliers, then you need to give another independent third party an opportunity to look at the basis for those changes and how you are planning to apply them. So then I want to assure Roy, who raised this question, that the tariffs for the KPA we have provided for a process of us being informed in good time, so that we also give an opinion on how the basis and how they are going to be changed. And again, the overall picture is to see how best can we be able to minimize on the cost of logistics. And so then even for the tariffs which are applied, be it by the public agencies, the government, there is room to be notified so that they become reasonable and they don't add up the cost of doing business. And this is also bound to be subjected to a lot of public consultations and participation, including even ours, so that we look into the bigger picture of how best do we make our route and our region quite competitive. And again, you will see the details of how this has been provided for in the actual regulations, and when we do the presentation in the second part. So I'll urge you to just listen to how that one says. And if you have any further clarification that you may need, I think we'll be able to respond. I wish to stop there, but before I do, Agayo, there are plans to have our people in Nairobi also met physically, so that we also have a public participation from the Nairobi people, from the Kisumu people, so that this process becomes an all-inclusive process that captures most of the people with some input to make across the country, not just Mombasa. So we'll meet you in Nairobi, we'll have some sessions in Kisumu, and we'll be able to capture all the issues that you have to say, so that you can understand. I don't know whether we responded to Daniel Tenui's question of licensing. You raised something on the registration of the clearing and forwarding agents. Roy also raised that one. I think Catherine will tackle that when she's doing her presentation in the second round. But if there is anything that we have not clarified, we'll be able to even explain further, so that you understand the whole issues that you have raised. I beg to stop at that point, so that the MC can proceed and move on. Thank you.
Thank you, Mr. Omingo. I think the comments, the questions were responded to effectively. The other comments or questions with regard to multi-charging, multi-licensing will be responded to during the next session. That is when the presentation on maritime transport operator regulations is done, and it will be responded there. Any other comments? The second round of comments for the participants on the Maritime Laws Amendment Bill 2021. Any other comments?
Yes, Chairman Kapeku.
Yes, Mr. Roy.
Yeah, sorry once again to come in on board.
Yes, no, it's okay.
We have also had some cases where some shipping lines or agents are registered. They come and open shop, and after a few months, they disappear. And more so, where it is painful is when they disappear with container deposits belonging to Karelian agents. I would want to believe that this regulation or the laws will have some clauses that prohibit or make it very hard for somebody operating as a shipping agent to run away with Kenyan hard-hand money. I'm saying that because there is a shipping line which used to, I don't know, a shipping line or an agent or who operated under the name Black Sea. We have many Krelin agents to date whose deposits disappeared with that kind of that shipping line. And not only that, others have also come in, swindled and disappeared. So we believe that the laws and the regulations that we are going to discuss, that we are discussing today, have in place mechanisms to make it very hard for the people to run away with our monies. Chair, I submit.
Thank you, Chair. Kindly participants, if you are not making any contribution, kindly mute your mic. All the participants, please, if you are not making any contribution, kindly mute your mic. Please, kindly mute your mic. Any other comments or input, question on the amendment bill? Any other question? Kindly feel free to interact, participate, please. We really need your comments to improve the draft. So it seems you have exhausted our comments, eh? Okay. I'd like just to make one comment, particularly on the issue of the local content. Eh? The WTO agreement on trading services provides for that. Under WTO agreement on trading services, there is what we call schedules of commitments. And under the schedule of commitments, all the countries, you have to specify specifically which sector, which subsector, if it is transport sector, on which subsector do you want to make any commitment? Do you want to liberalize? Do you want to put restrictions? Do you want to put requirements or regulations with regard to local content? And this is at the WTO level. We have over 90 countries who have different local content requirements at the WTO, even at the UN. So it is a common practice for local content provisions in order to protect the local, what you call companies, with a view to meet the national policy objectives. So in that regulation, you put what you call aspects of capacity building, especially the issue of the developing countries. When you compare the developing countries with the developing countries, we have different levels of development, different levels of trade. So the WTO agreement has given the developing countries that leeway in terms of progressive liberalization of their sectors, and also having the right to develop or enforce what you call domestic regulations to meet their national policy objectives. So that is in order. So any other comments before we close this first part? Then have maybe I don't know if you can have a head break. Catherine, you want to say something?
Ella's hand is up. Maybe she can say something.
Ella, kindly.
Thank you, Kapeku. I just need to shed light into something there, what Roy has brought up at the very end with regard to the maritime transport operators in the industry having come in, they do business for some time, and then they say go under, and they're not. It's not able to trace them. They've disappeared with monies from for the clearing agents, customers, and the like. When you look at the same has been provided for Roy, be rest assured, under the conditions for licensing and also for registration, where this is not just with regard to shipping lines or rather shipping agents. We also have cases of cargo consolidators, even clearing agents, whom we've not been able to trace them because we really don't have details. Either we are at the mercy of KIFA to give us the details about this particular clearing agent, or say KRA. But now with us being able to undertake registration of, say, clearing agents, if with the licensing, with the revamped licensing conditions for the shipping agents, we are able to have the details of who are the directors of this particular company, where is their location. And also, if you go deeper into the requirements, we are looking into the aspect of, has this company undertaken any change, say, in terms of directorship? And if that has happened, who are their directors? What are their details to enable us in case of such an eventuality, we are able to know how to assist the authorities to get hold of such companies. And also the issue of companies having an office. It's also one thing that has featured all through the conditions that have been set, because we need to know we can locate this particular company, say, in a certain physical office, where also after the licensing process or during the licensing process, there will be an aspect of due diligence to determine, indeed, this is where this particular company is located. And I know this also has been brought about by issues of briefcase companies that have swindled the industry players for some time. I think for more details, we will be discussing it in the next session, where now we are addressing issues of the term, the conditions of license and the requirements. Thank you.
Thank you, Ella. Any other comments, or we close this first session? Then we go to the next session. Any other comments? Okay, Catherine, kindly take us to the second presentation. I don't think we need a health break. This is a very short meeting.
Thank you, MC, and thank you, Ella. And as I proceed on my health break, there is a comment from a clarification from Jean-Baptiste. I request one of our panelists to see how they can assist in the response to that inquiry. It's on the issue of local content and immigration. Maybe somebody can address it so that we have that aspect addressed. Now, let me see.
Okay. I saw it's clear that all, Jean wanted to know, and to be clarified, that all immigration processes still go via the Department of Immigration, and that there is not any other administrative layer to be implemented by KMA. I think all the immigration issues are handled by immigration, the Department of Immigration. We are not doing any of the roles that they are playing. What we are doing is we liaise with the immigration to identify whether a particular applicant meets those conditions that we are putting. And any company that is bringing that person has already advertised for those jobs, and then there's nobody qualified to undertake those particular assignments in the country. And at that particular point, that is when we be able to give them the go-ahead to proceed and bring that party to come and work on board. But all the immigration issues are handled by immigration, not us. So we'll not be having, we only answer one question. Whenever those applications are done to the immigration, they will seek to find out from us whether the qualifications submitted are uniquely belong to that particular individual, and that such a person cannot be found in the country, in which case we'll be able to advise the immigration properly to deal with the matter. That is how we come in. Thank you. I hope that clarifies for Jean.
Mr. Mingo and Kapeku.
Thank you, Mr. Mingo.
Yes.
Thank you, Mr. Mingo. I just take the opportunity here to have one comment. So it's very clear, and we are in very close, all as international shipping lines, not only CMA, but I think I can speak for most of the shipping lines represented in Kenya. We are already in contact, of course, with the Department of Immigration, and it's quite clear, and the processes are quite clear. Maybe taking the opportunity here to clarify once again that when we evolve into an international, let's say, environment as shipping lines, you know, it's important also to make sure there is a sufficient diversity of profiles operating in each country. So it's always a right balance to find between too many expatriates and not enough expatriates. Huh? So on this, we all all shipping lines are, I think, are doing their best to groom local Kenyans, especially youngsters, because we want to attract more and more young local staff to our industry. It's important to bring the newcomers to our industry, and not necessarily only to the tech companies or finance or whatever. We need to attract more youngsters into the shipping industry, and so we want to groom these young generations, right? But at the end of the day, we must not lose from our eyes that to run an international shipping lines, you need a network abroad with your principals, regional offices, head offices, etc., etc. So at some point, you need also some international expertise, and we encourage as well as the shipping lines to send Kenyans abroad. It's very important for us as an industry to make sure as much as possible, as many as possible, Kenyans are also having an international experience, then to when they come back to the country and enrich the industry, the local industry with international knowledge. So just this comment to make sure we are not too rigid on what we call the expatriates or international contracts, and that we always find a clever balance between what international trade is recurring and what local trade is recurring. So thank you for your understanding on this. Hope this clarifies. Thank you. And thank you, Mr. Omingo, for clarifying.
Thank you, sir. Okay.
Thank you, Mr. Baptiste. Catherine, are you taking us with another presentation, or we break for 10 minutes?
Sorry, Mr. Kapeku, there's a question that has not been answered. Sorry, Mr. Kapeku.
Okay, yes, Mr. Gayo.
There's a question I raised, Mr. Roy raised, and Mr. Mutai, regarding the cost of doing business in terms of fees and charges that are done arbitrarily.
Yes.
We'd just like to receive a response if that is taken care of in the revision.
Yeah.
The industry suffers from arbitrary fees and charges. We are not calling for what we call unfair pricing, but just a process and procedure for enactment of new fees and charges and tariffs. And then finally, from me, does the Act have any new aspect in terms of enforcement and sanctions that makes KMA operate like, for example, the Communication Commission of Kenya? I submit. But Mr. Mutai, Mr. Roy, and myself raised the fundamental question about fees and charges discipline and the cost of doing business. Thank you. I submit.
Thank you, Mr. Gayo. As I alluded, this will be addressed in the next session. There will be a presentation on maritime transport operators regulations. It will be addressed there. Don't worry. It will be fully addressed. So maybe kindly, Catherine.
Yes. I can just say something.
Yes.
Just to add what you're saying. There are provisions for tariff review and tariff introduction under our Act. And there are provisions for failure to comply with these provisions also under our Act, the proposed Act. We also have provisions requiring compliance once the DG issues a notice for compliance. And there are repercussions also in terms of enforcement for failure to comply with that Act. This is under our proposed Maritime Laws Amendment Act. We also have similar provisions under the regulations. This is in terms of tariffs, costs, and any other directive. I hope that answers the question.
Yeah, we are provided for that.
Yes. I hope I've responded to your concern, Mr. Agayo.
And again, Mr. Agayo, we'll see how it flows in the MTOs. It is there provided. So Catherine will take us through during that session the provisions relating to aspects of the tariff, the consultations, and everything, and also the issue of sanctions and enforcement. So,
Yeah,
yes, yes.
Mr. Chair, this is Daniel Tanui again. Then is it possible for you to take us through this so that we know whether our questions are answered?
MC, I kindly request for the participants to indulge us. We have shared the draft laws on our website, and we kindly ask you to please find some time to go through them, and then you can share with us your comments on email. I noticed that time is actually running, and I also need to apprise you on the merchant shipping, maritime transport operators. If we go on to every specific provision that every participant requests, we might take the whole day. I kindly request you to indulge us.
Thank you, Catherine, for your
Mr. Daniel, that's okay?
I don't think so, because in a public participation like this, the things which are dear to us really needs to be addressed.
Mr. Tanui,
yep.
The laws are available for you to peruse through and to make your comment. You have until the 8th of December. The essence of public participation is to provide an overview of the laws, to allow you to raise questions during that session, and to give you room also to raise further issues, especially availing the actual law, so that you're able to inquire. If there's anything in this draft law that may not be clear, you are welcome to actually call us and consult us, and we can explain that.
Chair, with your permission. Chair.
Yes, continue, Mr.
Chair, I would like to associate myself with the comments from Mr. Tanui, that in this public participation, that is why we have a plenary question and answer. And indeed, I would have expected that answers would come forthwith, not by just being told to read and write. And again, Chair,
Sorry to interrupt, Roy. Let me clarify.
Again, Chair, the deadline of
Roy, through the chair. Can I intervene a bit through the chair? Roy, just a clarification so that we move. I was just saying that what Mr. Noy is asking is what the team was just about to do. You needed to seek some clarifications, and the chair has already instructed that these are captured in the presentations. So if you did not interrupt the presenter, you would have just proceeded ahead to present, and then you'll be able to raise questions and see how that particular matter is captured. So could we allow the presenter just to proceed to the next session on the MTO, Maritime Transport Operators Regulations, and then thereafter we can take in a set of questions to facilitate whether the issue that Anu is raising has been properly captured, or any further clarification. Is that fair enough? Roy, then you'll come there after Roy, so that we save on time.
Mr. Mingo, that looks fair if the issues are going to be tackled. But again, I was also saying the deadline of 8th December is too soon. I would want to propose that we delay by 1 week and then make the 15th. We give deadline of 15th of December as a final deadline, so that parties can sit and review, study, and make written submission. But when we talk of 8th December is next week. And next week, I don't think whether parties would have finalized to make their written submission. Chair.
Thank you, Roy. We've had you, and we'll respond to all your queries. Kindly let Catherine make the second presentation. Thank you. On Maritime Transport Operators Regulations, where the issues of tariff now feature in there. Thank you.
Thank you, our esteemed participants, for being patient with us. Now we'll progress on the presentation of the Merchant Shipping Maritime Transport Operations Regulations 2021. Now, the development of these regulations were as a result of various aspects. This includes, as we had said earlier on, the consultancy report on the alignment of the laws of the maritime sector to be in compliance with the provisions of Constitution, and this in terms with includes provisions in respect of providing for a fair administrative justice, terminologies that have been used, as well as availing information that can be available to all the public and and to those whose services are provided within the maritime sector. We've also implemented recommendations under Integrated National Transport Policy, and this is more so in terms of ensuring that we are able to regulate the provision of commercial maritime services in its entirety. We also have recommendations under the World Bank project, which provided on how we can strengthen our oversight capacity as the regulator for the industry. And we have also incorporated these recommendations within our regulations. In addition, you will recall that we have the obligations for the respective parties as well as those for the authority under the Mombasa Port and Northern Corridor Community Charter. And we have also incorporated this aspect to ensure that we're able to provide oversight in terms of efficiency, quality, costs of cargo, clearances, and processes. We have also incorporated recommendations in accordance with the third medium-term plan, 2018 and 2022. And this is in terms of facilitating growth for local content, for local entrepreneurs. And these you can see through the conditions for the respective maritime transport operators that we have provided. In terms of implementation of government directives on commercial maritime services, we've also incorporated this aspect. We have given effect to the International Convention on the File. We've also given effect to the obligations that we have under the GATS, the WTO agreement. We have incorporated aspects of the ministry's target areas and objectives, as well as that of the authority strategic plan, to try and see how we can incorporate regional and international initiatives for the growth of the sector. We've incorporated recommendations for the Blue Economy conferences in 2018. And also, you will recall at the very beginning, we had said that we had the Maritime Service Providers Regulations 2021, which were declared null and void on two aspects. However, we've incorporated the other aspects into our regulations, save for the wording and how it has been provided. We've also incorporated aspects of the Local Content Bill 2018, which has been emulated in other national legislations, which are actually in law for other regulators in the country. We've incorporated provisions in terms of the United Nations Conference on Plenipotentiaries on the Code of Conduct for liner conferences, as well as that for the minimum standards for ship agents. We have also incorporated the report of the Liner and Port Agency plenary meeting recommendations following the review of the minimum standards review. We've also taken into account benchmarks, not only of Germany, as we indicated earlier on, in South Africa. We've also looked at the provisions provided under the US, as well as our neighbor Tanzania, and seen how best we can incorporate our provisions. Now, the review process also for these regulations were again in consultation with the other institutions who have been listed. And the development of these regulations are in exercise of now the powers conferred under Section 8H and 16T of the MSA. You will recall that Section 16T is the new part to which we have introduced in terms of maritime transport operation services. Now, we have introduced different aspects and different parts. So under the Merchant Shipping Maritime Transport Operators Regulations, you will find upon a quick perusal or an overview perusal that we have made provision that touch on aspects of predictability, synergy within the industry, and stability. Now, these aspects of predictability and stability also touch on matters pertaining tariffs and costs. We've also talked about provisions that pertain oversight functions of the authority, and also provided for provisions in terms of enforcement. We have provided for provisions that address promotion of efficiency in provision of maritime service operations. And we've also talked about the establishment of a database of maritime transport providers. And this database is an aspect that also includes the registration of those that are licensed by related government agencies, and also those that the authority currently licensed. And this is more so to emulate national, regional, and international practice. So the essence of the regulations is generally to provide an efficient and effective, reliable, and globally competitive Kenyan ports and transport corridors. So under part 1, you will find the citation of the regulations, and you will also find several terminologies that we have defined under section 2. This includes who an authorized officer is, aspects of cargo handling facility, clearing and forwarding agent, inland container depot, freight manifest. We also have maritime transport operators who have also been defined in that interpretation: shipping line, shipment, a shipper, shippers association, shipping agent, and tariffs. Now, thereafter, we have section 3, which provides for the scope of services, which basically refers to the operators who have been provided within the first schedule. And these operators have been enumerated, each operator with the services that they provide. As you will recall, these are aspects that are actually contained in the old regulations, and they have been brought on board for continuation. We've also provided under section 4 the role of the authority with other related government agencies, and we've enumerated those aspects, which includes providing strategic policy direction, as well as monitoring and evaluation, and establishing linkages. Now, under part 2, you will note that we've made provision for registration and licensing of maritime transport operators. Here you will find provisions in respect of the registration of foreign shipping lines. You will also find provisions in respect of registration of local shipping lines. When you go to our schedule, and this is the second schedule, you will find the first schedule, you will find the form of application. The second schedule, you will find the form of the certificate or the license or the approval. And on the third schedule, you will find the form for the conditions upon which an applicant is supposed to observe. And in addition to that, we have provided provisions for licensing of ship agents, licensing of cargo consolidators, and these all are for, as they were in the previous regulations 2011, we have incorporated these provisions and noted that there will be a periodic application for renewal, including some of the terms and conditions provided. Now, in respect of registration of maritime transport operators who have been licensed by related government agencies, as we have indicated in our previous presentation, this introduction of registration of other maritime transport operators who have been licensed by other agencies is more so for building up our database, for availing an opportunity whereby we are able to monitor and provide oversight over these maritime transport operators. We've also provided that the aspect of registration will be on a periodic period of 3 years and will therefore not be annually. And some of the conditions upon which an applicant will be registered by the authority will include provision of a certificate of a valid trading license. Now, these valid trading licenses are those already provided by their respective related government agencies. This will entail those provided by KPA or those provided by Kenya Revenue Authority. So in addition to that, we have provided for conditions for all these maritime transport operators within the 4th schedule. The aspect of registration of maritime transport operators, just to reiterate, it's not only a national aspect, but it's also a practice that is entailed in other regulators in Kenya, a practice entailed in other international, other jurisdictions, not only regionally, but also in the outer jurisdictions. In addition, we've provided for provisions on renewal of license and of certificates for now the usual annual licenses for those that we license, and we've provided for enforcement and compliance provisions for all maritime transport operators. Now, under part 3, here we've provided for miscellaneous provisions. And under the miscellaneous provisions, we've provided the need to establish performance standards, and this shall be undertaken in consultation with the respective stakeholders. This may be the related government agencies in respect of cargo clearance, and also as well as the maritime transport operators in respect of now port operations, as well as now the chain of supply chain logistics. We've also made provision for aspects of monitoring and evaluation of performance standards as established within the industry, and the enforcement of performance standards as established within the industry. We have also provided for requirements for, as and when required, the authority may request for information. This is an aspect which was already provided in the other regulations which are declared null and void, and there was no objection to have this provision. Same goes for the provision for performance standards. We've also provided for provisions on code of professional conduct. You will recall at the initial stage of the presentation, we quoted anchored provisions in terms of code of conduct for liners as well as ship agents and other transport or other operators. So this is what has been captured and under this part. And we've also provided a provision for submission of periodic reports upon request for purposes of compliance with the regulations, as well as compilation of the final report. Now, as I had indicated earlier on, you will find our schedules. Under the first schedule, you'll find the scope of services for maritime transport operators, the forms for application with the licenses or the certificates for either approval or certificate of registration. Then you have a schedule for fees for application for as a license or for a certificate of approval. Then you have fees also for registration for other maritime related transport operators, which will be undertaken periodically after every 3 years, as well as now the conditions for all the maritime transport operators. And in these conditions, you will find aspects also of prevalence in terms of ensuring that we meet the local content, as well as ensuring that we're able to comply with the performance standards established and undertake the requisite enforcement measures as provided within the regulations for failure of meeting the performance standards. And I believe that is the end of the presentation for the regulations. And there we have the website where we have our draft laws, both the Maritime Laws Amendment Bill, as well as the regulations. And we have the comments email for you to submit your comments regarding the draft laws. Thank you.
Thank you, Catherine, for the able presentation. And I think you've seen the last page where is provided the published draft laws can be where they can be accessed, the link, and also the link for comment and reviews. I think we can invite now comments from the participants on this session presentation on maritime transport operators regulations. Kindly give your input, comments, questions on the draft regulation. Thank you. Kindly feel free to engage in this. Let's engage in this with a view of improving the draft.
Yeah, Kapechu.
Yes, sir.
Well, thank you once again. As earlier submitted on the issue of licensing, registration of Krelin agent. First of all, I don't want to take you back, but as Krelin agents, in Kenya, we have a proposed bill, which is probably going to go to parliament before your bill goes to parliament. And what exactly you've just put is what is contained in our bill. And in addition to what I said earlier, that Krelin agents are licensed by Commission of Custom, and at a regional level, we are paying $400 for the license. So any other license or registration, what have you, is duplicative. Because even before a Krelin agent is licensed by Commission of Custom, the issues of office location are determined. You cannot be given a license if you do not have a physical office and infrastructure to prove that you are able to perform the duties of an agent. So if KMA wants to register agents as a data, as a source of data, having their data, then no fees should be attached to the registration and registration of clearing and forwarding agents. And KIFWA is attached because we are also pursuing our own bill, which will cater for accountability of all clearing agents in terms of even to the extent of having liability clause of clearing agents. So for that matter, and we have already submitted in writing, particularly to that Schedule 9, we seek to have that matter vacated. Those three items, those three charges of 100, they said application processing fees, $5, initial registration fees, 200, renewal fees, which I would imagine it is annual. So that kind of, those charges are akin to a duplicate license, which we have one, which we pay $400 to Kenya Revenue Authority. And this is at regional level, and we cannot tax the clearing agents of Kenya, and make them pay $250, and yet we are competing in a regional environment where the agents in Uganda are not paying the same fees, and vice versa. So you are actually putting a burden. By introducing the fees is actually akin to introducing financial burden on Kenyan clearing agents. So for that matter, we support the registration, but we don't support the fees. So we request the fees be vacated forthwith as per our written submission. Secondly, I want to see the clause that addresses the issue of a password increase of levies, charges, decrease of container free period, and the like. These are things we need clearly put in the regulations so that, I mean, there is a kind of public participation and justification on why a charge is being introduced and why free period is being decreased and the like. Because we are in competitive world, and Mombasa Port is competing with Dar es Salaam. And the equivalent of KMA in Dar es Salaam is very strict, to the extent that the same shipping lines that are operating and lines that are operating in Mombasa are operating there. But there they comply, but here they don't comply. The issue of adhering to a directive by KMA, we have seen for the past 1 year, directives are issued and they are ignored. We need all those issues addressed. Otherwise, then we'll just be going back and forth. The issues of Chinese operating as a port clerk in our port here, while our agents cannot be allowed to operate as port clerks in Chinese, any of the Chinese port should also be addressed by these laws. So, Chair, I don't want to take a lot of time. I know my colleagues and other players have also their issues. And then again, the issue of shipping line closing, like I gave the example of Black Sea, and it went with almost about $50,000 for clearing and forwarding agents, and we could not trace no one anywhere. That should be addressed also by the laws. I would beg to submit it, Chair, for now, but let that be addressed now so that before we move to others. Thank you.
Thank you, Mr. Roy Mwanthi, the National Chairman of KIFWA. Any other participants? Any other comment from the participants? We invite your comments. Any other? Participants, let's actively engage.
Mr. Chair, can I?
Yes, yes.
This is Daniel. I think I addressed the same issues Roy has raised. One, we need clarity on who actually is the licensing authority for clearing and forwarding for CFSs. the licensing authority is ECMA. So we need clarity on, are we going to have double, we're going to be subjected to 2 authorities for purposes of licensing? And secondly, the issue of payments. Are we again going to be subjected to 2 payments? Because for licensing as a CFS, the process is exactly like what Roy Mwatha said. And we go through it and it's a tedious exercise. Do we really have to duplicate it again? If again, it's an issue of for statistics purposes or for purposes of registration, a simple registration for us would do, but not with the fees proclaimed in the act or in the draft. Then thirdly, we also need to know for these fees, what services is going to be rendered specifically to clearing and forwarding and the CFSs. And finally, really, we've seen a KMA which is, for lack of probably a better word to say, is one which has been toothless when it comes to helping some of the companies, some of the associations who are not either shipping line or KPA. We feel out there that KMA is listens more to the shipping lines and the Kenya Ports Authority. Are we going to see an institution which is independent and which has tooth to bite, so that when there's a complaint lodged on any matter touching on the bigger boys, action is taken? Thank you, Mr. Chair.
Thank you, Mr. Daniel Tanui, for your comments, and they will be responded to very soon or shortly. Any other comments before we embark on the responses? Any other comment for the first round? Okay, let's begin on the responses. The panelists, kindly.
Okay, can I start? And then
yes, I can start.
If I leave something, then somebody can also come and pick it. Thank you, Roy, and also Tanui. I hope there are also others who are listening and familiar with the issues and will also be raising. We had hoped that everybody got these proposals in time, read through, and then it becomes very, 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 very productive when it comes to actual speaking like we are doing now. But if any case you didn't get to receive them or you have any challenges, please just let us know so that you can be able to read them very clearly. Now I'll just respond to Roy first. The Roy and his group, they were the first ones that we met. I don't know whether Roy made it, or if he made it, he may have come late. I think he made it in the first group, he was there. And we had also reiterated the need to read through, to pick issues, and then let us know in good time. So that first category that we met 2 weeks ago will have very sufficient time to be able to respond. But in terms of the duration that Roy had requested we extend, I think that is something that the team will just look at, see how it unfolds as we receive your various comments. Now, we are not licensing clearing and forwarding agents. As earlier explained, we just do this for the purposes of knowing who they are, because certain issues, as Ella had already explained, I don't want to repeat it again. It is important to know who they are so that we can be able to work together. And so the process that they go through when they are licensed by KRA. We don't go through that process again. And the issue of the fees, you have raised your concern. We have taken note, so we'll be able to deliberate and see how it unfolds. The important thing with public participation is that you are free to raise an issue that you are not comfortable with. And we are assuring you that this is the zero draft, that the purpose here is to pick out the views, and then we'll be able to digest and see how best can we be able to interpret it, so that when you get now the final document, you can see whether or not your issue has been sorted out. So there is a clarity on who is the licensing authority. And as far as clearing and forwarding agents, that is quite clear. We are not licensing clearing and forwarding agents. We're just registering them for the purpose of knowing who they are, so that when issues do arise, we can be able to see how best to trace where they are. Then are we, okay, that has been cleared. And again, the issue that Anui raised in terms of the interactions that you may have had with the KMA in the past is also a fact that we try as much as possible to address the issues that the public raises. But the common understanding of a regulator works with laws. He cannot do anything that is not defined in law. And a regulator is not there to bite. Our laws, if you look at them, they are not biting anybody. We are just trying to create a platform that can give us a way of dealing with the challenges that the consumers of the services face, plus the service providers. And so then, in terms of developing that framework, I don't want to call it a teeth. The main reason why we are sitting here today discussing is that we are looking into regulatory framework that can help us to address the issues that consumers and providers of these maritime transport services they face in the industry. So that should such a problem do arise, then we have a very clear-cut way of dealing with such a matter. And this is the framework which has been lacking, particularly for the maritime transport operators. So the feeling that there is no teeth from the KMA perhaps could be a consequences of lack of that kind of framework that we are calling upon you to read thoroughly and make a very formal response, so that we can be able to address some of the issues that in your own judgment, you may have felt KMA is not dealing with quite effectively. So our effectiveness is defined by the extent to which you are able to read the document, find out areas that you may add some value, so that we are able to address future problems that do arise. And whether we have teeth or not having a teeth will be determined by the fact that there is a law provided to deal with the issues, and we are not following this particular law. You know, in the past, for lack of regulations, sometimes it becomes very difficult to even administer what you can see is very, very unfair on the side of people who are receiving the services, or on the side of the service providers. It is quite unfair, even on the side of the importers, when you see the demurrage rising to almost 10 times the cost of the actual container. And you see, when somebody insists on that, there must be some limits and controls and fairness in terms of dealing with the issues. And so then, without speaking a lot on this, I just want to urge you that we need a governance framework, and the governance framework is defined by law. So your input in this process will really help us. And you can do a report card on us once the laws have gone through and we are failing to implement what the law says. If you fail to implement what the law says, then there you have the right to say that we have given you teeth, but this problem is happening and you're not acting. But in the absence of a framework of handling issues, sometimes it can be a bit tricky, even you as a regulator, if you have to implement things. But now we are glad that we have a framework. We will be able to see how best, if it goes through, then we'll be able to see how it works. As to Roy was talking of a bill. Roy, we looked at your bill and we commend you, but we ask you to subject this to the mechanisms that are established in the country that make laws, the parliament, the attorney general, plus your stakeholders, and see how best we can be able to work together. Otherwise, it may not augur well to have two independent issues from independent parties. And you as a consumer and a provider of the services, if each and every party or service provider came up with their own bill, then what kind of a framework are you going to have in a country? So we support your bill. We want you to self-regulate, but there is a more structured and a better way of dealing with the issues. And we'll support your bill, and we'll also we have gone through and we'll see where there are conflicts. We need to address them even before you submit your final document, so that we don't subject it to glaring sort of lack of understanding. So we want you to harmonize and see how it works. How do you fit in respect of what you are asking for in your bill, in the context of what the regulator has also put in to be able to address the same problems? There must be some harmony coming in and seeing how best it can be best approached. And there are agencies and the experts who are able to help you and help us so that we work together in harmony. I think that is all I can say on the few questions that were raised. My fellow panelists are also free to comment so that we can pick another set of questions. Thank you.
Thank you, Mr. Omingo, for your good comments and the responses. Any other panelists to provide comments or responses?
Yes, maybe if I can say something small before, I think Ella also wants to come in and say something. So I will just request our participants, maybe when they have time, they look at Regulation 9, which provides for the registration, and just reiterate that this registration is only for, it applies for a periodic period of 3 years. And I will just also reiterate the sentiments made by Mr. Omingo that this registration, it does not apply as it does not act as a trading license. The trading license is still with the respective parties, and that this is a practice that is also adopted in Kenya. I think that is all that I'd wish to provide at this juncture. And I thank you for the comments and the recommendations made by the participants. Thank you.
Thank you, Catherine. Ella, you wanted to say something?
Yes, Kapeku, thank you. Maybe just to also shed some light on something that Roy raised with regard to the tariff and fees. I think, Roy, I will refer you to the maritime laws, the bill, where under section 5 DPK, we provided for a provision where basically it says develop a framework for rationalization of fees, tariff, and charges of maritime transport and logistics services. The spirit behind this basically is to curb the aspect of arbitrary introduction of charges, something that we've struggled with as an industry for the past few years, and then also just going forward to enable to curb this tendency of arbitrary introduction of charges. The maritime transport operators at the time of licensing, they will be required to present to the authority the tariff for that licensing period. And in addition, they'll be required to have this tariff displayed at conspicuous places within their offices. They also still under the conditions for licensing for maritime transport operators, they will be required also to have in place a system for dealing with inquiries and complaints from customers. This is inquiries related to services in general and also aspects of the tariff changes or the tariff reviews, which actually we expect if it's not addressed at that point, that is when you come, it's brought to the authority with the framework in place, we are able to establish and to ensure that the framework that has been proposed for undertaking tariff reviews is followed to the latter. And this ties up to what my colleague Kapeku had said earlier with regard to being the best practice as far as international trade is concerned. So we are not introducing something that is new. This is an international practice. And I think going forward, it will be good if as an industry, we embrace it so that we can just have that harmony as far as logistics and service provision is concerned. Thank you, Kapeku.
Any other resource for the panelists? From my side, I'd just like to make also some few comments. Under the Tanzanian Shipping Agency Corporation, there are regulations with regard to fees and charges on various maritime transport operators, clearing agents, container freight stations, and even terminal operators. And this is where one of the countries which we benchmarked. And in their regulation in Tanzania, for example, empty container depots, they are supposed to, for them to be registered, though they are licensed by the Tanzania Revenue Authority, they are supposed to pay an application fee of $50 and also an annual license fee of $2,500. For the CFS, they are supposed to pay an application fee of $50 and also a registration fee of $4,000. And for the clearing and forwarding agents, they are supposed to be registered. The local are supposed to pay $100 and the foreign clearing agents are supposed to pay $200 as the registration fees. And also the local have to pay $20 for application fee and the foreigners have to pay $50 for application fee. For terminal operators, depending on the type of cargo which is being handled, and also depending on whether you are you're operating at the seaport or at the inland waterways, the registration fees ranges between $750 to $4,500. So this is a benchmark. In other countries, for example, Tanzania here, just our neighbors under the ESC, they are charging even very exorbitant charges. And that is one comment I would like to make. The other issues, the Shippers Council raised the issue of the what we call the sanctions and enforcement. And even in our regulations, there are penalties for offenses which have been provided, and Catherine will maybe shed more light on that in terms of contravening the provisions of the regulations. There are penalties on that, which include even fines and also imprisonment. With regard to the issue of tariff, I think my colleagues have really gave valuable contribution on the same. What I would like to say is that for a long time, we have been, since 2011, Omingo has already said, we've been operating with a weak enforcement mechanism due to inadequacy in terms of legal and regulatory environments. And it is one of the rationale why we are amending the legal and regulatory framework to be able to create that condition to be able to serve all the players in this in the maritime sector, not only the service providers, but also the users, so that all benefit and they operate in a conducive environment, in an enabling environment. So we need your support to be able to support this legal and regulatory framework. We have had so many challenges. If we want to address them, let's support this legal and regulatory environment framework. Let's make our input so that we are able to move forward. Otherwise, those are my submissions for some of the comments. Thank you.
Yeah, Chair.
Yes, Roy.
Yes, thank you, Chair. Once again, Chair, it is very strange that you benchmarked the registration fees and the like, what you want to charge with the Tanzania, and yet you did not benchmark the local shipping charges being charged in Kenya and the was being charged in Tanzania. Whereas Tanzania local charges is $125 per 40-foot container. And Kenya, it is going up to $400, depending on the lines keep on fluctuating, the charges keep on fluctuating with shipping line, but minimum being above 300. Yet Tanzania is at 125, a fixed price. Why would you want to benchmark partially on licensing of clearing and forwarding agents and depot owners, and you do not benchmark on local charges, which is actually eating the port of Mombasa. That is one. Number two, it is evident that the licensing of carrying and forwarding agents and the part that you want to take, it is actually contained in the proposed Kenya Custom Agents and the Freight Forwarders Bill 2020. This bill is being actually, it's on the stage where it has to be presented to the Committee of Parliament for deliberations. And more so, what you have proposed is just a duplicate. It looks like it is just copy-pasted from Kenya Customs Agents and the Freight Forwarders Bill to your Maritime, your proposed bill. And as such, you should leave carrying agents to self-regulate. You should not regulate them. But if your registration is not going to cost anything, then we are not opposed to it. But as long as it is going to be charged, for us, we will take that as license fees, and we are all uniform in the region. We are all uniform. We pay only $400, nothing more. So you will get a resistance when you want to register at a fee. But if you want to register for data collection, please open our portal. We shall all register as a requirement and don't charge us anything. So I want to submit.
Maybe let me respond somehow. The issue, there was a question on the fees charged commensurate with the service delivery under the WTO agreement on TFA, the article on fees and disciplines. The issue of the service, the charges should commensurate with the fees or the services. What I'd like to say is that even besides the issue of statistical data or in terms of regulating the clearing and forwarding and the others which are being registered, I think also need to read the regulations about what will be the role of KMA in terms of regulating the MTOs. There is the provisions there on the issue of the performance standards, which have incorporated aspects of the WTO, the agreement on the IMO FAL convention on facilitation of maritime traffic, and also aspects of the Mombasa Port Charter. So there will be services which will be provided. This is a control tool, and also to show that there is commitment from the MTOs in terms of the regulation process. Any registration without some charges, I think we'll have what we call some weaknesses. There is need for the MTOs to be committed in terms of their service delivery standards. And this requires just a small commitment in terms of payments, in terms of this service which will be provided, in terms of implementation or enforcement on matters of performance standards. So we'll be able to review the issues, and also we've had your comments, and we'll also consult further and we'll respond to them appropriately. Thank you. Any other comments from the participants, or any other response from the panelists? If you want to add any comment or a response on the MTO regulations, kindly, the participants, we invite. Yes.
Maybe I can say something just before we open up to further participants. I'd wish to remind us that the inclusion of regulation of related government services of agencies licensed by related government agencies was actually an aspect that was also provided in the Maritime Service Providers Regulations, which were declared null and void due to those technical aspects. So the two technical aspects we had mentioned earlier on. And when the court, during its decision in that judgment, had no issue, and nor did it feel that the regulation of the related government agencies was an aspect that should be left out. It was found to be sound and constitutional. And it is in this premise that, notwithstanding the overriding objective of the authority under Section 3 of the Kenya Maritime Authority Act, as well as the preamble of that act, as well as the Merchant Shipping Act, and more so Section 8, which provides for provisions on regulation of the maritime transport of operators, that there is no part of which seeks to exclude certain maritime transport operators in their regulation as compared to others. It is this spirit that we have now carried forward into our proposed regulations. And the actual regulation, as we have clearly stated and said by the other panelists, it includes aspects of monitoring, evaluation, coordination, among other aspects. So that's all that I needed to add, just as an addition towards this discussion. Thank you.
Any other comment? Thank you. Welcome, sir.
Thank you, Catherine and Kapeku, for clarifying those particular aspects. And you only use the word, Kapeku only used the word benchmarking, but when you do benchmarking, you look at the bigger. You don't just visit one party. But we've taken note, like I had said earlier. We just want you to be very, very straightforward in putting the issues, and then we are assuring you that we are looking at the various positions and matters that are raised, and we'll be able then to see how then do we make it fit in so that it can serve all the purposes. And again, further to what Catherine has mentioned, when it comes to the logistics, any party who is involved, who has a role to play in the efficiency, in the overall efficiency, must be able to have its activities monitored and evaluated. And it is this role of monitoring and evaluation that now we come in to provide. And we do it both for the private sector and for the government agencies who are involved in the actual delivery of logistic services. And there is so that we look at the entire chain. If you don't focus on any particular area, then whatever gains that you may have made in the area that you're looking into will not be realized. And so then we foresee, by implementing these regulations, we foresee a situation where even the government agencies, particularly now that we have a common understanding that there is need to reach a certain level of efficiency, that there is a need to be accountable for errors that may have been omitted or committed, so that we are able to see how best we can improve the ease of doing business and the cost of doing that particular business. And in that regard, we have a very important role to play once these regulations are in place. And we are working very closely to make the port charter work and help us to get this accountability framework that everybody has been wanting to be realized. Together with we are working with the Kentrade, we are working with the KRA on the various systems. And as we implement this, you'll be able to see the realization of what everybody wants, the reduced cost of doing business through those frameworks that these regulations provide for development, and through the monitoring of efficiency that this framework is providing for. And so then when this benefits the industry and our role becomes much, much clearer, because now we have the tools, then you'll be able to see some of the benefits that will be derived for the implementation of these particular regulations. That's what I wanted to comment and assure the participants that is what we intend to do, and it will work out for the good of everybody, the country, and the region at large. I just want to stop at that particular point, and thank you so much for the time.
Thank you, Mr. Omingo. Any other comment from the participants? Any comments from the participants?
Chairman, I don't know whether you still allow me or it's been too much.
Yes.
Apparently, it appears that we don't have too many participants. And as Roy has said, and as Mr. Omigo has actually said, we need KMA to be strong. And we need KMA to pass laws which would not be subjected to a lot of litigation. The issue of these applications and tariffs really needs to be relooked again. And I suggest we probably have a session, a targeted session with the concerned parties. We iron out that so that once the document is presented, it's a document we all own and not a document where we feel that it's a document we're not happy with. And the first thing we will do is challenge it in court. So I would rather we have a working document which talks to us and a document which we are fully participated in. There are two issues, main issues. One is on tariff, the second one is on application fees and the regulations governing who regulates ourselves. Because we don't want to be regulated by multi agencies. It makes business very difficult to do. So we support this, but engage us, specifically the three issues I've spoken with about. Engage the clearing agents, engage the CFSs, and any other party which wants to be involved in probably a closed door meeting where we go through all these things and iron out any issues we have. And once we are in agreement, I think the document would be good to go. Thank you very much for hosting us and for allowing us and giving us a chance to make our presentation.
Thank you. Thank you, Tanui.
Thank you, Mr. Tanui. I think those are valid comments. I would like to urge the participants again also, kindly read the documents. Go through all the provisions. If needs be, engage your legal experts. Kindly go through the maritime draft laws, check the provisions, recheck again, read again. From then, you can be able to see what are the weaknesses and also make comments or give your submissions with regard to the areas which need to be strengthened. I think it's important for everyone to read the draft laws because some of the issues have been provided for. So kindly, please, I know sometimes we are too busy to be able to go through these documents, but it is imperative that we go through these documents. Please, I beg of you and I urge you. Any other comment before we close the session, maybe? Any other comments?
Mr. Kapeku.
Yes, sir.
Ogambi, I appreciate what you have said about the need to read the document. And I apologize for deploying laziness. Is it possible to highlight where there's a change from this to this and the justification? And then again, is it possible for the consultant, and I think she's done a good job, just to tell us what has been introduced anew, just for ease of reference and constructive contribution? When legal documents become so lengthy, a number of us, including myself, may just feign ignorance and just read it and ask difficult questions. So just a summary of what section has been changed. It was this is a new provision, and this is a reason for the new inclusion. And as I've said in the one, we support a stronger KMA. I mean, we have always been looking forward to that, and this is known from the Shippers Council. But my concern again is the introduction of registration, fees that will be applicable. And truth be said, in Kenya, registration construes lengthy processes, lengthy procedures, and often a cost to it. And that's our reservation. And we are already suffering multiplicity of taxes and fees, and that worries us as an industry. So that would be my ask of now. And thank you very much.
Thank you, Agai Ogambi, for your comments, and they'll be taken into consideration. All the proposals will be responded to. If you make the written comments or written proposal, they'll be responded to officially. Any other panelists who would like to make a comment or a response or an input?
Yes, Chair, we requested for an extension up to 15th of December to be able to make a conclusive written submission. Please confirm that deadline has been extended to 15th December.
Through again, Mr. Roy will consult and will also give a response to that. Kindly be patient, please. We'll give a response to that. So I think in the absence of further comments.
Apologies, sorry, Akapeku, there is Dennis Munganga who's trying to unmute and he's not able to unmute. Maybe our ICT can unmute him so he can talk.
Hello,
Okay.
can you hear me now? Can you hear me now?
We can hear you very well, Dennis.
Yes, I can hear you. Yes.
Thank you very much, Chair, and all the panelists and the organizers of this session. I'm Dennis Muganga from the Northern Corridor Secretariat. I just wanted to appreciate the involvement of stakeholders in this process and provide just a few comments. It is indeed in our interest to have a strong maritime authority as a regulator of this industry, and therefore we are very much in support of this process, and we hope that it will help to strengthen KMA and all other stakeholders in this sector. One specific area that I wanted to comment on is, was there any regulatory impact assessment undertaken before embarking on this process? Because I think that's usually a good starting point so that we are able to appreciate what has worked, what has not, any strengths and weaknesses, and also pick up the needs of the industry players, so that then goes into informing what we do going forward and the kind of changes that we want to incorporate in the new laws that we are making. So I think that's important. Another thing is, it will be good to have good coordination of all players in this sector under the leadership of KMA. We have had a visit to the different countries in this region, in East Africa region, and during our discussions, especially when we discuss about inland waterways, there's always a feel that the other countries want to come and learn from Kenya. They want to see how Kenya Maritime Authority is regulating this industry, what it is that they can borrow. So I think it's important for us to continue taking that lead role. It's important for us to showcase what can work and how it can be made even better, and then be able to correct any challenges that we may seem to have, because the other countries in this region look up to us. And I think that's a compliment that we need to take up and sustain. Finally, I think issues of safety, issues of maritime security, issues of environmental conservation, issues of pollution control, these are areas that probably need to come out more strongly and be adopted as areas that need to be tightened and controlled even further. So I think in general, those are the areas that I can comment on now. But on behalf of the authority, we commit to read these articles in detail and provide our written comments. Thank you very much.
Thank you, Mr. Mganga from the Northern Corridor, for your valuable comments. Thank you so much.
Thank you, Dennis. Dennis, we really appreciate very concise and precise input into what we ought to do. And Meshkuru Sana, we'll make sure that it's done. Maybe I don't know whether Catherine has something to say with the impact.
Yes, thank you, Mr. Omingo. Thank you, Kapeku. Thank you very much, Mr. Muganga. Maybe just to provide an area whereby there was an assessment undertaken would be under the World Bank project. You recall that during the introduction of my presentation, even from the very first presentation, I had indicated that there were several reports that were developed and recommendations were made towards reviewing our laws to enable us to become the ideal regulator for the maritime industry, both for the safety, the security, and the pollution aspect, as well as the provision of commercial services. So these have been provided within this table, within these reports, which we can, I believe they are already online, so they can be available, or we can access some of them at the academy, at the authority. And in terms of the aspect of coordination, we have also introduced or enhanced our provisions for coordination under the Maritime, the Laws Amendment Act, as well as the regulations. So we'd encourage you to continuously read it and to assist us on how we can improve it further. We appreciate that we are seen as the leaders in the region, and we intend to emulate that through the progression and improvement of our regulations and our laws. So that's all that I need to say, and say thank you.
Thank you, Catherine, for your contribution and your responses. I think we are on the last agenda item, which is way forward and closing ceremony by Madam Florence Otieno. Is Madam Florence around? Madam Florence?
I think Madam Jane Florence is unwell, so she will not be able to attend today. Maybe as a way forward, I could just briefly summarize before the closing remarks. We have taken note of some of the recommendations and the proposals made by this by the plenary, by our esteemed participants, which we shall take into consideration as we review the laws. We've also taken into consideration the proposals that have been made to caucus further in groups, and we welcome you to visit our offices so that we can have that discussion at a convenient time to both. We ask you please to continue reading our draft laws, find time to read them, and submit your responses on email. We check the emails every day just to ensure that we don't miss out on anything. We will discuss on a possibility of extending with our principals, and then we will communicate this to your emails as to where we sent. For those ones who did not get the actual email, we appreciate that you have availed your email addresses on the chat, and the rest we will also share if the period be extended. We'll indicate exactly when and until what date. This will also be communicated to the usual channel of communication and also through the social media, among other platforms. I think that is all that I have, and thank you very much for being patient with us. Thank you.
Mr. Omingo.
Thank you. I want to thank everybody once more. Thank the chair and the rest of the team that have made this possible. And assure you that we are moving forward into considering all the inputs that you have done. And you have no cause to feel that you have not been given a chance. You have been given a chance. You will always be given a chance. You can document, as chair has already requested, so that this time, as Tanui had wisely given in his words of wisdom, that we must all come up with a document that we all own and accept and are in agreement is able to address all our issues. And that is what we are out for. So then I just want to thank everybody, Mr. Gayo and his team. I just want to thank you so much for taking time to listen to us. And so then we look forward to concluding this thing without necessarily going through those various other challenges that we faced in the previous one. And so then even as KIFWA, even as ships agents, even the ship sergeants had requested for further time to be able to look into some of the issues. I hear Kifo is also recommending some very close consultation to see that we harmonize some of the issues so that we don't encounter problems. Because in Kenya here, we have made the court system very, very easy to access. I don't know. The only thing you need to do when you don't like something is to take it to court. And there was no public participation, there was no constitutional something. They always find words to say. We don't want that. So let's all move together, give the process of support, and as we look forward into coming up with a document that serves all the parties, it's going to be a win-win document for all parties who have the interest to see the governance frameworks of the sector is improving, and then we are able to achieve the things that we want to see as a country. So then on behalf of the Director General, I just want to thank you once more for the time and the opportunity that we had to share together with you. Thank you very much.
Thank you, Chair. And somebody should volunteer to pray for the closure of the forum. Any volunteer to pray? Kindly, it's always good to start with prayers and end with prayers. Any volunteer, preferably a lady now, gender sensitive. Preferably a lady to pray for us. Any volunteer?
Pray. Let's pray.
Okay.
Father Almighty, in the name of Jesus Christ, we want to thank you for having been with us throughout the session, Father. We want to thank you for the discussions we've had, Father. Even as we leave this meeting and get back to our respective duties, we still need your guidance, Father, even as we continue to have offline engagement with regard to the proposed law. We also request for wisdom from the Father. In the mighty name of Jesus Christ, I pray. Amen.
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 I think we bring the meeting to a closure now. We thank all the participants for their valuable contribution. And as the acting DG has said, consideration will be made to all the proposals, and we'll give you feedback on the same. Thank you so much for your commitment and sacrificing your valuable time to attend this forum. Thank you, and God bless you all.
Thank you, Joseph. Nice afternoon.
Good afternoon to you all.
Do we?
Sawa. Yeah, it was not. Hata haikuenda.
you.